What is the new Supreme Court landmark ruling? Has it made the open category a quota, and how it is going to impact the recruitment exams and also the seat allocations? The Supreme Court has gone ahead and made one thing very clear, that the open category belongs to the merit, not to any social label at all. Hello everyone, welcome to Vajram and Ravi's Flash News. My name is Shubhangi Singh, and today we are going to understand this clarification and the judgment that has come from Supreme Court. What do they mean by that the open category is going to be available based on merit? Why this judgment has come along? What was the initial issue and what clarification has been given? So let us start with understanding that what exactly was the dispute in front of the court. So recently what had happened, that there was a recruitment exam for judiciary and the recruitment was to 2,756 posts. Now for this particular exam, there were two stages. One was the written exam and second was a typing test. So in this category, if the people cleared the written exam, then they were qualified to sit for the second test, and in the end, based on the aggregate marks, the final list was to be prepared. Now, the authorities based on the first test prepared a category wise shortlist. Now, this is where it got disruptive, and this is where the confusion came in, because the authorities which created the cutoff list for general, they had marked it around 196, and for many reserved categories it was unusually higher, up and until 220. And furthermore, for the reserved category, they did not include the students who had cleared the cutoff based on general. So people who had applied through reserved categories, they were put as per the higher cutoffs. If they did not clear it, they were nowhere in the list, even though they had cleared the general cutoff of 196 marks. So in this context, many meritorious students who were not able to clear the reserved category list, because if they were not put in this particular criteria, they were excluded, and it also resulted in less meritorious students being included in the main list. Now all of this was a dispute where we got to see that can merit override a social category, and this is where this dispute initially went to Rajasthan High Court, and then it came in front of Supreme Court. Now based on the facts of this dispute, Supreme Court went ahead and clarified that if we are talking about reserved category, then the reserved category candidates cannot be excluded from open post. When they cannot be excluded? If they qualify on merit. So let's just say reserved category, if the open list, open criteria was of 196 marks and they have got more than that, that means they will be able to be in the part of the list. They cannot be excluded from it. And if they are being excluded, it is violation of fundamental rights such as Article 14, which promises equality before law, and Article 16(1), which talks about equality of opportunity. Just because a person has a social identity does not mean that we will not take his merit into consideration. And furthermore, Supreme Court has clarified that when we are talking about open category, it is not reserved for general category people. It is basically an open pool of people and it is based on merit. So anybody who gets more than 196 is qualified for that open category. You cannot separate reserve category, put them in a higher mark category and then exclude them from open category. So in this context, Supreme Court has clearly went ahead and said it applies only to certain year-marked post. And if you are treating open category as exclusive, then you are creating some sort of communal reservation which is not present, and this is again incompatible with our fundamental rights such as Article 14 and 16. Now, this clarification that has come from Supreme Court is very important to bring clarity to recruitment processes and also seat allocations, because this was on very much similar lines to what Rajasthan High Court has also said. If we talk about the judgment given by Rajasthan High Court, you have to understand that they clearly held the reservation of framework is valid. When they are saying that this open category is not to be limited to general category, that is not questioning the reservation framework. The only thing that needs to be kept in mind is the category wise list, and they cannot be prepared based on just open category reserved for only general category. So, in this context, they have also explained that category wise lists are not illegal, but you have to keep in mind that first the open category must be filled based on pure merit. Once the open category has been filled, irrespective of the social label, irrespective of the reserved category or general category, then the reserved list must come after, so that the merit gets priority and so that merit based placement is available as a right under equality, not as a reservation benefit for people who are clearing the exam based on merit actually. Now, on this context, when we have understood what Supreme Court has clarified and on what note Rajasthan High Court had given the verdict, now let us also understand that why exactly we are discussing and understanding this particular judgment, because it adheres and affects the recruitment design. And when we are talking about recruitment design, it affects all the exams that you sit for. Now, when we are talking about in this particular recruitment design, the only thing went in wrong here was not reservation. It was basically the spacing and marking of the category segregation that was done. Now, what was done here? The segregation of candidates was done already before making the open merit list. Had it not been done, open merit list was made first and the people who had qualified were put in there, and then later reserved category would have been opened. This would not have become a problem, and lesser qualified candidates would not have shortlisted and more qualified would not have been excluded, and merit would not have become a penalty. And all of this situation has raised serious questions about equality of opportunity, which was denied, and this also highlighted a structural flaw, not individual failure, that is present in the recruitment process. So, all in all, this clarification puts the structural issue hopefully under maintenance, and hopefully the correction will also come along. Now that we have some clarity on the judgment, now let us move to two other important things that were part of this judgment and that need to be discussed. So, one question that has come along is around the Estoppel argument that has been mentioned in this particular clarification. So, when we talk about Estoppel word in law, it basically means to stop. When we are saying what exactly it means or it infers, it basically says that in order to avoid inconsistency, one person cannot refrain or go back from his own argument. So, in this context, the argument from the agency and the recruitment procedures holders that came that if these candidates are giving the exam and they are participating in the exam, then they cannot go ahead and challenge the procedure of the exam. And this is what they used in their Estoppel argument. That means candidates do not have the right to challenge it because they participated in the exam, and that makes this inconsistent in terms of behavior. But on this context also, court went ahead and simplified and gave a reason to the whole situation. They said just because candidates are participating, it does not mean they are accepting the procedure, especially the illegal part of the procedure. So, if something is wrong in the procedure, that needs to be corrected, and the Estoppel argument does not hold any place here. Furthermore, when we are talking about illegality of the procedure, in this context, student or the candidate could not have understood the illegality because it was only after the results that this illegality was understood. And if there are any constitutional violation, then they are always justiciable, they are always there, and fundamental rights in any order cannot be waived or compromised. That is why this Estoppel argument will not work. Now, another important question that came in terms of more like a confusion came after this clarification, that if we are talking about open category being accessible to reserved candidates, does that mean that reserved candidates are getting double benefit? So, on that context, you have to understand that court has also given clarification on that and formally rejected that no, the reservation benefit exists only when there is relaxation in mark or relaxation in age, or if there is any relaxation in fees. If the reserved candidate is qualifying without any relaxation, that means he is not using the reservation and he has scored above general cutoff. So, in this context, he is not using the reservation benefit at all, and the selection is happening based only on merit, not on reservation. So, if the selection is happening only on merit and not reservation, then there is no conversation about double benefit in this scenario. And now, as I said, because this is a crucial Supreme Court judgment that has come along, especially in terms of recruitment process and seat allocation, this will have direct impact on governance as well. Because here we will get to see that it will apply to all public recruitments. It will bring in redesign of cutoffs, it will bring in changes in shortlisting algorithms, and it will also help in preventing reverse discrimination that we get to see very much prevalent in our society as given point of time. And furthermore, this very judgment is on the lines of the principle of Indra Shawne case, which is more famously known as Mandal Commission case, which put a cap of 50% on reservation, which talked about non-exclusion of creamy layer, and Saurav Yadav case of 2020, which again clarified that the quota policy does not intend to deny the benefits to the reserved candidates. And that is why this judgment again reaffirms the principles of open category, which is open to all, be it from any category, and merit cannot be logged by any given identity. And reservation has always been to ensure inclusivity, not exclusive behavior. Now, that was all from my side. What are your thoughts on this? Let me know in the comment section. That was all. Thank you so much.